Hi everyone. I hope you can hear me. So today we are going to be talking about the new parole in place that is basically going live today. Okay. It is going into effect today, and you are going to be able to start applying for it. I do want to go over what the requirements are because now we kind of know what exactly USCIS is looking for and looking at when it comes to these requirements. The rules that are supposed to be in the Federal Register are still not officially published. They will be officially published tomorrow. However, we have access to the unpublished one. So we're going to go through the unpublished one and see exactly what the requirements are, who actually qualifies. Remember, they talk about, oh, criminal history, what criminal cases count, what criminal cases don't count. We didn't know that, but now we do. So we're going to be talking about all of that in this video. We're going to go through the unpublished version, and then we will go through that. If you have questions, please put them in the comments. I will be responding to those as we get through this video. Remember, any questions you have, even if you're watching on the replay, feel free to put them in the comments. If you want to know if you qualify for this based on your specific situation, go ahead and schedule a strategy session with me, because that's the only way I'll be able to actually give you individual advice on your particular case. On here, I can give you general information. I can answer the basic questions. However, when it comes to your particular eligibility, I won't be able to do that analysis on here. So go ahead and schedule that strategy session. You can do it by going to my website, lilylegal.com, and clicking on contact us. So let's jump right in. Trying to get my layouts correct. All right. So that's not the one I like. Perfect. So the first thing we are going to talk about is, of course, excuse me, is the form. So the form is going to be a brand new form, okay? USCIS decided instead of adding it to the I-131 and, just updating a couple things on that form, to create a completely separate form, which is going to be the I-131F. And that's the form you will have to use when you file for this parole, okay? And like I said, the process starts today, August 19, 2024. So you can go ahead and get started. Again, that's if you have all your required documents, you meet all the requirements, and you are eligible, right? That's really the key here. And the reason that a lot of my clients were waiting for this to come out, to make sure that they are actually eligible and not applying for something that they don't qualify for. All right. So that's the first thing. The form is the I-131F, and the date that you can start filing is August 19th, today. And the next thing I want to cover is, who is this actually for? Is this actually going to be beneficial to anyone, or is it just, USCIS doing things? So for non-citizens, right? So basically they did a survey, and out of 2/3 of non-citizens that are married to US citizens do not have status. They entered without admission or parole. Okay, they entered, they did not have a visa, they did not get paroled into the US. That's 2/3 of the non-citizens that are married to US citizens that fit into this. So, and those, right, those are the people this is for. So it's really important to understand who it's for and why it's so important, right? And when it comes to these, this is 94 pages. All right. This rulemaking thing is 94 pages. And I did have to go through all 94 pages before I went live because, again, the point of all of this is to give you information and make sure that you are getting accurate information. Feel free to read this for yourself. I am going to skip certain parts of it that are not really about the requirements and more about how they came to this conclusion that this will be the requirements. Okay. So basically, their whole thing is they want to save US citizens some time and make sure that they get to keep their families together if they qualify. All right. So let's talk about what this does not do. And they want to make that very clear. So applying for the parole does not mean that USCIS is saying that your marriage is real. It does not mean that USCIS will automatically approve your I-130 and your green card application. That is not what this is saying. This is saying that you meet the basic requirements for the parole and there's a humanitarian or other reasons to approve your parole. Okay? It is not saying that you meet the I-130 requirement or that you meet the I-485 requirements. So there may be other things that prevent you from eventually getting a green card, right? That you may need a waiver for. This is not saying that you're going to now not have those things in place. This only means you now, if this is approved, you now have a path to getting a green card in the US without needing an I-601A waiver, without having to leave the US. So really, they really wanted to make that clear that there is still additional steps that you have to go through after you get this parole before you can get a green card. All right. So this is the most important thing to remember, because I've gotten so many calls, so many questions about, okay, I entered with a visa, I overstayed my visa. Do I, am I able to apply for this and get that work permit for 3 years? Well, no. Okay, the only reason this parole exists is for non-citizens who are applicants for admission to the US, meaning you were not admitted to the US and you were not paroled into the US. So you are still seeking admission to the US. Once you are inspected and admitted or paroled into the US, you are no longer seeking admission into the US. So again, it is so important to remember this point, because this is going to affect whether you can apply for this. Because sometimes you think, well, I'm here and I'm undocumented because I overstayed the visa. Am I able to apply for this to get at least a temporary, parole and then a work permit? This is saying no, that you cannot do that. You have to stay with what your admission, basically. And the other thing to keep in mind is if you are married to a US citizen and you were admitted into the US on a visa, even if you overstay that visa, your US citizen spouse can still file a green card application for you because you're an immediate relative of a US citizen. But if you entered without inspection, without parole, well, your US citizen spouse will not be able to do that for you. But once you have the parole, they will be able to do it. So that's really the key here. It's not to give you status, it's to make it possible for you to then apply for a green card. All right. So this is kind of a longie, but let's talk about this. This is basically saying, the first sentence is, USCIS will exercise its unfettered discretion in administering this process and prioritizing requests consistent with the statute and any applicable regulations. It means, right? It means that USCIS is only going to make a decision based on their discretion, right? You don't have a right to get a request for evidence before they deny your case. You do not have a right to get a notice of intent to deny before they deny your case. If they get your application and they look at it and they say you do not qualify, you do not qualify, right? They can choose to deny your case without a request for evidence, without a notice of intent to deny. On the flip side, they can choose to send you a request for evidence if they feel like you're missing something and they want to see that before they can approve your case or deny your case, right? It's really up to them which way they go. So you don't really get a choice in this, right? USCIS is basically saying here, by the way, you can apply for this, but it's up to us completely on how we handle your application. There's no rules that say we have to send you a request for evidence. There's no rules that says we have to send you a notice of intent to deny before we process your application. Right? There's no rules that says that. So they're basically letting you know ahead of time that they can choose to deny it, which is gets me back to, you want to make sure you qualify and you have all your documentation ready to go before you file. Because if you get that officer that says, I don't think I want to issue a request for evidence, or I don't think I want to issue a notice of intent to deny, they can go ahead and deny your case without sending you anything else. Right? They send you the receipt notice, they send you the biometrics, you go get your biometrics, and they make a decision. So you want to make sure that your application has every single thing that will make it possible for an officer to make a favorable decision in your case. You do not want to, send incomplete applications thinking that you can supplement later. Like they have to send you a request for evidence. This is saying they do not have to send you a request for evidence. They can just make a decision based on what you sent them. So be very careful with that. If you are working with a lawyer, they will obviously make sure that what you're sending in is what needs to be sent in. But it's really, really important that as you're going through this, know that there's no appeal. They make that very clear. Right here, they make it very clear. There is no administrative appeal. So if they deny your case, the only thing you can do is reapply. Right? You can't appeal it to the BIA. You can't appeal it to anyone. Their decision is their decision. So it's really important that as you're making decisions on when to file, what documents to include, that you are really taking stock of the fact that your initial application needs to be solid for USCIS to actually process it. It's really, really important. All right. So the next thing is, if you have been convicted of a serious offense, you will not be eligible for this. Okay. They are basically drawing a hard line. If you have been convicted of a serious offense, or you pose a threat to national security, public safety, or border security, there are other crimes that will give you a presumption of ineligibility. By serious offenses, by serious offenses, we'll get to that later, but they're really talking about felonies. Okay, they're talking about felonies. So if you have a felony conviction, this is saying that you're not eligible. However, if let's say you have a misdemeanor, there is a presumption that you're not eligible, but you can rebut that presumption. Meaning, if you present enough evidence that shows that you should still be able to get this, that you have, strong ties to your community, you have, all these factors, all these positive factors, that USCIS may still choose to approve your case even with that misdemeanor. However, with a felony, like you'll see later, they are not looking to give that any pass. They're saying serious offenses, no luck on getting this parole. And that's why it's so important. Like I said before, it's really important that before you file anything, you know all the details, because we did not know any of this. Okay, all we know is that certain criminal offenses would be a problem, but they were not clear on what those offenses are. All right. Another group of people that will not be able to apply for this, right? Presumptively, right? There's a you're ineligible, and then there's a presumptively ineligible, meaning they're saying you could technically apply for it and we could find that you meet certain requirements and go ahead and approve it, but we're just going to assume that you do not qualify unless we see something in your case that makes us think that we should approve it even with that presumption. Okay. So they're saying that if you have an unexecuted final removal order, you are presumptively ineligible. So this means you were in immigration court proceedings. They found you removable. The judge issued a removal order. You appealed. The appeal did not work, but you never left the US and ICE never took you physically out of the US. So that's an unexecuted final removal order. With a unexecuted final removal order, they're saying there's a presumption that you do not qualify. There is exceptions, right? There is circumstances that's going to make them think that you should still qualify. We're going to talk about that later, but just know that's another one. So the felony convictions, definitely not eligible. Misdemeanor convictions could be eligible if you have positive factors, right? If you have an unexecuted final removal order, could be eligible if you meet certain requirements. Okay, so they are very, very strict on some of these things, but we want to talk about it, right? We're going to talk about it. The fee for this is going to be $580. There is no fee waivers. Okay, you must pay the $580 if you want to apply for this. There's no fee waivers. Okay, you must pay the $580 and you must file it online. That's the second thing. So you must have the fee ready to go and you must file your application online. They are not accepting paper applications at this time. So create that online account as soon as possible so that you have it ready to go once you have you've determined that you qualify and have the documentation to move forward. All right, so now let's talk about the criteria, right? This is, right, they gave us some samplings at the beginning, right? When they first announced this, we kind of knew all of these things, but now it's concrete. Okay, once they publish it tomorrow, it'll be officially concrete. So they're saying you must be present in the US without admission or parole. You have to have continuously physically present in the US since June 17, 2014. So that's 10 years from when this was announced. Okay, just keep that in mind. June 17, 2014 to present is what they're looking for as far as your 10 years in the US. If you've been here longer than that, that's great, but they do want those 10 years. You have to have a legally valid marriage to a US citizen on or before June 17, 2024. Okay, legally valid marriage to a US citizen. On this, they are not looking at the viability of the marriage. I will say that. Or if the marriage is real, they're just looking for a valid marriage because guess what? They know that when you file your I-130, USCIS will get to dig into your marriage and make a decision whether you qualify for the I-130 or not. They don't want to make that decision. They just want your marriage certificate to prove that you are legally married and you have a legally valid marriage. That's all they're looking for. You have no disqualifying criminal history. Remember, if you have a serious criminal history, a serious criminal conviction, you are going to be disqualified. Okay. And then you have to do your biometrics, undergo background checks, security checks, public safety checks. They really want to make sure that you are not a threat to national security or to the public in general when they decide to give you this parole. All right. So basically, you need to provide documentation to account for the 10 years, right? This is really important because I've had people ask me if they need to document every single day of their 10 years here, every single week, every single month. This is basically saying that you need to document your state in the US as reasonably, as much as you can, get granular as much as you can, but this is also saying that they are not looking for you to document every single day or every single month, but they want direct evidence, right? Direct evidence that shows them that you have been in the US for those years, okay? If you can have month to month, that's great. If you can show, 10 months out of the year, and it's just like 1 or 2 months that you, for some reason, don't have any documentation for, they're saying that that could be fine. Okay. So do not get too, in your head about this needs to be every single day. I need to document every single day. No, that's not what they're saying. Okay. It's really important to pay attention to what they're saying. It says every day or every month. It's not necessary. Okay. There is no requirement that every day or month of that period be specifically accounted for through direct evidence. Okay. They're saying it. I'm not saying it. They're saying it. So it's really important that you don't disqualify yourself because you just don't have, a couple months of evidence. They're saying that you could still be eligible, still be able to show your physical presence without showing every single day and every single month. Really important. And I'm glad they included that because it makes such a big difference. All right. And then here we're talking about the parole for widows and widowers. So here's the thing though. When you look at the requirements, everything they've published up until this point, it's just talking about spouses of US citizens that were married as of a specific date, right? That's all, right? As of June 17, 2024, they do not mention what if your spouse passed away, right? What if your spouse, passed away on June 16th? Do you still qualify? This is saying yes, you can still qualify if one of two things is true. You have an I-130 pending or approved. So before your spouse passed away, they filed an I-130 for you, and that I-130 was pending or has been approved. And then your spouse passed away. Or if your spouse passed away and there was no I-130 pending, that you filed the I-360 for the widow and widower special immigrant status. So basically, there is a status that you can apply for if your U.S. citizen spouse passes away before you get status. Right? If your U.S. citizen spouse passes away, you can apply for this I-360 for widows and widowers. And this is saying if you file that within the time frame that you're supposed to file it, which is within 2 years of your spouse passing away, and it's still pending or there's been a decision made on it, you can still qualify for this. So keep that in mind. There is that carve out for widows and widowers because it just makes sense to do that because they may be out of status and we're waiting to do a 601A and then their spouse passes away. So it's really important to kind of include them in all of this. Okay, so now we're going to get more into the criminal charges. This is where things get a little more detailed, okay? So all pending criminal charges are disqualifying. I'm not saying it, they're saying it. All pending criminal charges are disqualifying regardless of the nature of the charges. Okay, so if you have a case that is currently open, right, You're still going to court for it. You have a criminal case. It's still open. You're going to court for it. There hasn't been a decision. You're waiting for trial. You do not qualify for this parole. You have to wait until there's been a final decision on your case, right? Either you were found not guilty or your case was dismissed or something. There has to be a final decision on your criminal case for you to qualify for this. So if there's no final decision on your criminal case, you do not qualify for the parole. And again, this is why we want to know what this qualifying criminal history is that they talk about, because they can say that, but we wouldn't know what it is unless they tell us. Okay. And that's why it's so important to do this. Right. So next one, like I said, all felony convictions, including felony DUIs. So all felony convictions are disqualifying. So if you have a felony conviction, you are not qualified. Okay. And they even list out the ones that, even regardless of whether the offense is classified as a felony or not, you could still be disqualified. All right. So they're saying felony conviction, automatic disqualification. But even if your crime is not classified as a felony, but it fits into one of these things, you are also disqualified. All right. So even if it's not classified as a felony in your state, but it fits into one of these categories, you are also not allowed to get this parole. So murder, torture, rape, or sexual abuse, offenses involving firearms, explosive materials, or destructive devices, offenses relating to slavery, peonage, involuntary servitude, and trafficking in humans, aggravated assault, offenses relating to child pornography, sexual abuse, exploitation of minors. All of those crimes, no, whether your state classifies it as a misdemeanor, but if it's into one of these, you're still not allowed to get this. And then domestic violence, stalking, child abuse, child neglect, or child abandonment. Does not matter if it's a felony or not. You would still not qualify. All right. Controlled substance offenses, other than, right, they're making an exception here, other than simple possession of 30 grams or less of marijuana. So if you have any controlled substance offenses, what is classified as a misdemeanor in your state, other than simple possession of 30 grams or less of marijuana, you do not qualify. And I will tell you the reason they put that 30 grams or less. There is a waiver that you can apply for if you have 30 grams or less of marijuana simple possession. If you're in that situation, there is a waiver you can apply for that will still let you get a green card through marriage. But if you have more than that, there's no waiver for it. If you have, intent to distribute charges, there's no waiver for those. So that's why they're making that clear here. They're not saying that you're automatically going to qualify for a green card. You may still need to apply for a waiver, but they want to make it clear that you wouldn't qualify for a green card anyway. So why are we going to give you this parole that's meant for people that can get a green card? So it is all very, they are very specific, and it is good to pay attention to that because it's going to affect whether you can apply for this or not. And this is one of the things that we really wanted to see, their definition of the criminal history that's disqualifying before we filed anything. All right. And then it says all other criminal convictions, except for the ones I just talked about, all other ones, excluding minor traffic offenses, will result in a rebuttable presumption of ineligibility for parole in place. So even if it's not a felony, even if it doesn't fit into all of that other things, you will still have this presumption that you do not qualify. And you can rebut that presumption by presenting mitigating factors, right? So that is really important. And what are the mitigating factors? So this is what they will look at. So if you have a criminal history that is not a felony and does not fit into the other things that are disqualifying, then you need to look at these factors and make sure that you are presenting evidence that shows that you fit into these factors so that USCIS can still approve your case, but they need you to present them evidence that will overcome that presumption. And the more things on this list that you can show them, the better. So the first thing is the age of the conviction. You need to make sure that you have a certified copy of your criminal disposition to make sure that they have all this information, because they will be able to see the age of the conviction. How long ago were you convicted of this? Is this something that happened like a year ago, or is it something that happened 20 years ago? So it's really important. The further back, so let's say it happened 20 years ago, you have a better chance to show that remoteness than if it happened a year ago, right? The next one is the age. So your age at the time the offense and conviction happened. The younger you are, the better, right? So if you were a minor, it's a better situation than if you were, 50 years old when the conviction took place. And then they also want to look at the sentence and the penalty because, again, if you had actual jail time versus if you had pretrial probation, they want to know how intense your sentencing was. Evidence of subsequent rehabilitation. So community involvement, things like that will help with the rehabilitation, right? Showing that you have changed your life since that incident happened. They will also want to know the nature of the conviction. Was it a violent incident or was it not? Whether the conviction was an isolated offense or if you had like multiple criminal histories, right? They really want to pay attention to that, because if it was just one offense and there was nothing else the rest of your life, they want to see that, and they want to they will give you credit for that, right? If you had mental or physical conditions that contributed to the criminal conduct, they also would you can provide evidence of that. And then rehabilitation, right? So if there was a mental condition that contributed to it and you have, sought mental health treatment and you are currently in treatment, they want to see that. So you want to make sure that you're including that. They want to look at your particular vulnerability. So it's really important that you pay attention to them. And then they're looking at the requester's status as a victim of or witness to a criminal activity such as domestic violence. So they really, really want to make sure that you are presenting as much things that will make an officer look at the criminal history and have things that they can use to basically say, you know what? Yes, this person has a criminal history, but look at this, all these other things that show they are a good person and they will be a good member of society. Basically, that's what they're trying to say. The requested status as the primary caregiver, again, it's all these things to show that you have, things going on for you in the US and people relying on you. If you or your spouse are current or former members of the military, please include that documentation, because it will help. Things that show your good moral character, like just basically everything and anything that you can think of to show that you are a good person and deserving of this, you should be included. Okay. Like I said, if you have an unexecuted final removal order, you will be presumptively ineligible for the parole. Okay, so it does not mean that you automatically do not qualify. It just means that there's a presumption that you do not qualify and you have to convince USCIS that you do qualify. So That means also, let me repeat what unexecuted final order means. So, unexecuted final order means that you were in immigration court proceedings, you were given a removal order, you never left the US, and the US government never took you outside of the US. Okay, that's unexecuted. It only gets executed if you left the US. So if you've never left the US since you got your removal order, it's unexecuted. And they're saying there's a presumption that you don't qualify, but you can try to convince us that you qualify. So to convince USCIS that you still qualify, you need to show these things, right? You need to show that you did not have notice, right? So lack of proper notice, for example, if you missed a court hearing and you were removed in absentia, showing that you did not have proper notice will help make this better, right? The age of the age of the non-citizen at the time of the removal order is also important, because if you were a minor, all of that makes a difference, right? Versus if you were an adult. Ineffective assistance of counsel or being a victim of a fraud can also be a factor here that you can use to show that you still qualify. Okay. And then they do have the extenuating factors that you can use. If any of these things apply to you, right? That's the important thing. If any of these things apply to you and you know you have an unexecuted final removal order, you want to make sure that you go ahead and provide as much of these things as possible with your application. Again, it's not an automatic no, but it's more of it's a very strong maybe, okay? Unless you have something to show that makes it a yes, okay? So USCIS is not saying no, they're saying convince us, okay? It's more of a convince us to continue your stuff, okay? And oh, and just so I can say this, if you have questions, put them in the comments. I do want to get through these factors and then I'll get to your questions, okay? So just bear with me. There is a lot to get through. Like I said, this is 94 pages of things, and I am skipping over the reasoning part of it. So they have all the rules, and then they have the reasons why they made certain decisions when it came to the rules. So I will be skipping those just to make it less hectic and make this video less long. But we're gonna get through all of this. Try to kind of get to the things that matter the most. So another thing that USCIS wants to see is, why should they exercise favorable discretion in your case? Remember I said earlier, this whole parole thing is up to USCIS officers. It's in their discretion. There's no appeal if they deny your case. They get to decide what they want to do with your case. Okay, so you want to present them things that show that you merit favorable discretion. Okay, and they're even giving you examples of things you can use to show favorable discretion, which is showing that you have ties to your community, you have children. That's a big one for me. Is if you have minor children that rely on you and those children are US citizens, if you have elderly parents or in-laws that you are the caregiver for, your length of stay in the US, the longer the better, right? Your age. So if you're old versus young, if you're in the middle, it's not, middle is not really favorable factor. But if you are like 70 years old or 6 years old, right? So that's where advanced age or young age comes into play. If you're a caregiver for individuals with disabilities, including your US citizen in-laws or siblings, they are counting those, okay? Typically, in-laws and siblings don't count for a lot of immigration things, but they are counting those. So that is great. If you have physical or mental conditions requiring treatment or care in the US. So if you are sick and you are currently in treatment, you want to present evidence of that so that you are being taken, you can stay in the US and continue getting those treatments, okay? If you have status as a victim of or witness to a crime or civil rights violation, labor rights violations that's under investigation by a labor agency, okay, you can present evidence of that. They're very specific, okay? They're very specific on what they're looking for. You can present evidence of the impact on your family if you were given this parole or if you were not given this parole. What is the impact going to be on your family? This is where a detailed statement comes into play, okay? This is where we do a detailed affidavit for your family showing exactly how you not having status has affected their lives and how it may continue to affect them. And then showing the status of your spouse, whether they're in the military or former military members, okay? So basically, any other thing, what they're saying here is any other thing that you can present to show that they should make a favorable decision in your case, you should, okay? So present as much evidence as you possibly can. That's the key here. Present as much evidence as you possibly can to show all of these factors. Again, the form is the I-131F. That's what they're going to use and when you're filling out the application, and the application has to be filed online. And then as far as documentation, I do have a video where I talk about documentation, especially proof of ID. You want something that has your picture on it. Okay, valid passport, driver's license, if your birth certificate has your picture on it, any government issued ID that has your picture, date of birth, and photo, like your full name, date of birth, photo, that's what they're looking for. All right, for physical presence, at least since June 17, 2014, anything you can get, okay? These are the documents that they have listed, so IRS transcripts. I would suggest, yes, you typically have your 1040 tax returns, but they are being very specific with the tax transcripts, not the tax returns, but the transcripts that come directly from the IRS. So you can get those online on irs.gov. If you create an account, you can pull it the same day. If you are not able to create an account, you can request that it be mailed, and it will be mailed to the last address that you had on your tax return. But it's really important that you do not just send in your tax returns, but your tax transcript that's coming directly from the IRS that proves that you actually did file it, okay? Your rent receipts, utilities, deeds, mortgage, rental contracts, bank statements. So basically, they are giving you a whole set of lists that you can use to prove this. And then evidence of your marriage certificate, right? Marriage certificate showing that you were married as of June 17, 2024. Really important. All right. And then if either of you have ever been married before, present the divorce decrees, annulment, death certificates showing that those previous marriages ended. And then if you're applying as a widower, you want to also include the death certificate for your spouse. All right. Proof of citizenship status for the spouse, right? These are the proofs that they are looking for. It's really important that you have, you know, all of these things ready to go because, again, USCIS wants it. Arrest records, again, I say include your certified copy of the disposition, okay? Do not just print out something from the website that's not certified. You want a certified copy of your records because that's what USCIS has wanted in the past, and that's what they're going to want in this situation. So that certified copy will make your life easier. And like I said before, all of these things is up to USCIS discretion. They can choose to just deny your case without ever sending you a request for evidence for the certified copy, right? And then you'll have to start all over again. So it's really important. Include the stuff. And then for stepchildren, remember this is for spouses and stepchildren's of U.S. citizens. Birth certificate showing the relationship between you and your parent, your proof of ID, evidence showing your physical presence since June 17, 2024. This is important because it doesn't require you to have been in the U.S. for 10 years like a spouse. So this is just for stepchildren. Evidence showing that you establishing a legally valid marriage between your parent and your step parent, and that marriage took place before June 17, proof of U.S. citizenship, arrest records, all those things. This is another important thing. Again, the fee for this is $580. There is no fee waivers. And all applications must be submitted online. All right, those are, if you take nothing else out of this, the fee is $580. There's no fee waivers, and all applications must be filed online. There's no paper applications. USCIS may change their mind later, but there is no paper applications at this time, and there's no fee waivers either. Okay. So if you have ever been, I will get to your question, Manny. That's a good question. Okay. I will get to that soon. Let me just, I have a couple more things here, and then we can get to the questions because the questions are where it's at. So how is USCIS prioritizing which application they process first? They're saying they are going to prioritize people that have filed an I-601A. So remember, if you're the spouse of a U.S. citizen, you entered without inspection, the only way before this parole program, the only way for you to get a green card is to do an I-130, then do an I-601A waiver, wait for that to be approved, leave the U.S. for your interview, go to your interview, be approved, and then you can come back to the U.S. But with this parole, now you get to skip that whole thing and get the parole, apply for the green card in the US. So they're saying because these people already filed an I-601A or they already have an I-601A approved, we're going to prioritize their case because they already started going through that process. So that is the reason, okay? They're not trying to play favorites. They're just saying these people already started going through this system the way we want them to. So we're going to give them the advantage of prioritizing their case over others. And then what do you get if you are approved? You get a parole into the US, right? Remember, paroles are granted on a case-by-case basis, and it's an exercise of discretion. We know that. But you get it for 3 years, up to 3 years, and you can apply for a work permit. Okay. And also, once you get it, you can apply for your green card application through your spouse. That's the other thing to keep in mind here. All right. So one thing people have been asking me, and I'm so glad they included this, is what happens if I file and then I'm denied? Am I going to end up in immigration court proceedings? Well, they're saying here that generally, I'm just going to read what they said. DHS generally will not use information contained in a request for parole in place under this process for the purpose of initiating immigration enforcement action against the requester, unless, right, generally they will not, unless DHS determines in its discretion, right, there's no rules here, it's up to them, that the requester poses a threat to national security, public safety, or border security. So if they feel that you pose a threat to national security, public safety, or border security, they will or they can put you in immigration court proceedings. And this is why you should be very, very careful before you file anything, especially if you have a criminal history. All right. Remember, if you have a felony conviction, you don't even qualify, but someone's going to tell you that you can. And then once you file, if they find that based on your criminal history that you pose a threat to public safety, they can put you in immigration court proceedings. So it's really important that you look at your qualifications, make sure you qualify before you start this. Okay. All right. So that is all of it. I will go through this again. Like I said, 94 pages. We're going to go through it again and just make sure there's nothing else. Because, you know, sometimes you have to read stuff like multiple times to make sure you get every single detail. So I am going to now get to your questions. If you're joining me live and you have questions, put them in the comments. If you're watching this on a replay and you have questions, put them in the comments as well. This is a longer live than I have been doing lately. It's just, there's a lot. There was just a lot to get through. All right. So first question, Francisca. My daughter filed for her dad and I on March 2023. I received my green card 6 weeks ago, but her dad's I-130 has still not been approved. What do you think? Honestly, it depends, right? Depending on his history, depending on if you two were married when your child was born, all of that can be a factor in I-130 process. So for parents, when U.S. citizen children are filing for their parents, mothers are easier, especially if you have a birth certificate that was issued close to the time the child was born. That is easier for mothers. For fathers, sometimes they do require DNA testing or it's just a longer process. It's not always fair, but that's just what we have seen in practice. March 2023, you're still technically within the normal processing time for these things. So just be patient. And if you are outside the normal processing time, do a service request. Okay. Next question. Hi, Femi. I want to renew my EAD AP based on pending VAWA. Can you please confirm the mailing address? So the mailing address is not Vermont. You need to go to so those are two separate forms. It's really important to keep that in mind. So USCIS is having all the applications, I believe, go to Nebraska, Lincoln. So you need to look at the actual filing address on the USCIS website for the forms that you're trying to file. Okay, so keep that in mind. So, and last time I checked, Vermont was not the address to send those to. They've been trying to kind of centralize everything, have it go to the service the sorting center, and then it gets sent out to the different places. So you want to make sure, but it should be on the USCIS website for the direct filing for each of those forms. All right. Oh, good question. Hi, Letty. For a final removal order, what are good documents or reasons we can submit to overcome presumption of ineligibility? So we did go over that a little bit. USCIS has a whole list. So it's really important to go through that list because they really want to make sure that you are showing the reason that you have that removal order, right? If it was an in absentia removal order, you're going to need to show why you did not show up to court. Okay. So that's something that's really important to them, and they want to make sure that if you're not showing up to court, why did you not show up to court? All right. So I'm just gonna share my screen one more time to just show you what those things are that they're looking for. Okay. So over here, you can see they are looking at the lack of notice. Again, lack of notice is really more for in absentia orders of removal. So if you were removed in absentia, they want to see, okay, did you not have notice of your hearing? And that's why you didn't show up, or did your notice to appear not have a date and time? Did immigration not send you the notice to your right address? Things like that. They're looking at the age of the person when the removal order was issued. So the younger that you are, the better. Or if you're like really old and you're just not able to get to court, if you can document those things, they are looking at all of that. Ineffective assistance of counsel, or if you were a victim of a fraud in connection with your immigration representation. So there are people that their lawyer just did not give them proper legal advice and they were able to show ineffective assistance of counsel. You can document that to overcome that presumption. If you were a victim of a fraud, let's say someone that is not a lawyer basically defrauded you, took your money, and gave you poor advice when it comes to immigration proceedings, you can present evidence of that as well. And then they are also looking at if there was a language barrier, and that's why you didn't, your case didn't work out, your status as a victim of domestic violence, basically any other factors that makes it that impacted your ability to appear or have your case processed properly. A physical or mental condition as well can be used to show why you were not able to properly how do I put this? How you were not able to defend your removal proceedings and get that final order of removal. Remember, this is not just for in absentia, but if you were removed in absentia, you do need to show that it was kind of beyond your control why you didn't show up. And then if you're, I think I didn't mention this, but if you're currently in removal proceedings, meaning there's no final order of removal, you can still apply for this. There's no presumption in those situations. So Letty, I hope that answered your question. Great question. Naturalization after June 17, still eligible for this program? Unfortunately, we do not know. Like, it's not extremely clear, but the date that they're looking at, and they're very specific with saying married to a U.S. citizen as of June 17th, 2024, meaning your spouse. So my understanding of them using that language is saying your spouse that you were married to on June 17, 2024 was a U.S. citizen, right? So on that date, you met all the requirements. So that's how typically these programs work. Did you meet the requirements on that date? And if, let's say, your spouse later on becomes a U.S. citizen, you did not meet that requirement on that date. So my understanding of it is that you would not, someone that naturalizes after June 17th would not, their spouse would not qualify for this. All right. How do you respond to questions? Have you ever charged? I'm guessing, have you ever been charged with, arrested for, convicted, etc.? If no, if not arrested or charged, charges filed due to pre-trial probation completed. Well, typically there is a charge, and then the disposition is that you did pre-trial probation, and then the case gets dismissed. You still have to disclose that. Okay. you still have to disclose that. So have you ever been charged with anything? Arrested? So for you to get pretrial probation, typically you have to have been charged with something, right? It's going to depend on your state, but typically that's how that works. One misdemeanor in California, no arrest on file, alternative. So again, you would want to document that. You don't want it to be a situation. Let me say this. You'd want to overshare in some of these things, especially when you know there was no charges and there was no conviction, right? You want to overshare because you want to make it very clear to USCIS what's going on. You don't want them to ever think that you are trying to hide something. Okay. Again, so it's going to, so yeah, so if it's automatically sealed, the case is still there. I want to make that clear. So if it's sealed, it just means people can't have access to it, but that doesn't mean that it never existed. So when they say ever, they mean ever, not as of today. Does it show up on your records? It's really important to understand the difference there. So sometimes when you get your case, when you get your records wiped and sealed, you think that for immigration it doesn't matter anymore. For immigration, it still mattered. It means that at some point you had those charges. Just because you had it sealed does not mean it never existed. It just means when someone does a basic background check, it may not show up. Okay. But if you have been arrested, if it was disposed of where you were not actually convicted of anything, it will not hurt you to show that you have not been convicted of anything, right? We're trying to show positive factors. Okay. So don't be afraid to disclose that. Again, it's about ever. It's not about today. So even if, so for example, let's say you were charged with a crime and your governor decided to pardon you. You were still charged with a crime at some point. It's just not on your record anymore. You've been pardoned, but it's still there. So when they say ever, they do mean ever. Okay. Not currently, but ever. All right. So I do not see any other questions. If you have questions, please put them in the comments. And by the way, if you're getting value out of this video, feel free to hit that like button. It just lets people know that this is a video that they should be watching. And if you would like a personal consultation where I actually go through your specific immigration needs and see what you qualify for, if you qualify for this program, what documentation we should be getting together to get you on the path to getting this program applied for, go ahead and schedule a strategy session with me. You can do that by going to my website, legal.com, and clicking on contact us. You can pick a date and time that works best for you. To do that, if you're watching this on Facebook and YouTube, the link is in the description to the video. All right. Question here. Hello from Las Vegas. Hi. I'm married since 2005. I entered the country with a B1, B2 visa. My husband is American citizen. Actually, we are living in different states now. Okay, Reza, you did not finish your question. Okay. All right, so I'm going to wait for you to finish your questions because I'm not sure. I'm just gonna wait. Once you finish your question, then I can answer it, but it's just coming in pieces. So go ahead and do that. If you do have questions, put them in the comments. This was a lot of information. Like I said, it was like 94 pages of things that came out today. So we want to, I wanted to come on here and talk about it. I know I could have done a live on Friday, but the unpublished regulation was not out yet. So it wouldn't have really been super helpful to do a live on Friday when we don't have all the information. But now we have, I don't think anything is going to change between today and tomorrow when they officially publish it. But again, I always go back once it's officially published to just compare the two, make sure nothing has changed, and all of that. So if anything changes, I'll be back here talking to you about it. We are going to be doing a deeper dive into the criminal history part of things and the removal deportation part of things as well, because those are the biggest things when it comes to this thing that's going to really affect people. So I will be doing a deeper dive into those two things. So feel free to join me on Friday when we talk about that. All right, so let's get back to Reza's question. All right, so I've been married since 2005. I entered the country with a B1, B2 visa. My husband is American citizen. We are living in different states now because of his dog in New Mexico and had his son on hospital. Can we apply for status being in different states? It depends. You still have to show documentation of why it's necessary for you two to be in different states, why you can't join him in New Mexico or him move to Las Vegas. So that's kind of where you need to really look at your particular situation, what documents you have to show that, and then also have documentation showing your relationship. So even if you're living in different states, if you are still able to show your relationship, like you're flying back and forth to see each other, you're talking to each other constantly, you two have a joint bank account, you have all these things, even though you're living in separate states right now, you have plans to move back together at a certain point, you have an actual plan for that. Those are things that USCIS is going to be looking at, and you want to document all of that. You don't want to kind of leave anything out because that's going to make a huge difference. So make sure, if that's the case and that's your situation, document everything and be able to explain why you're not living in the same state. All right. Let's see. Manny, we are submitting bank statements. It would be a good idea if we combined all 1 year rather than submitting separate PDF files for each month. Yeah, that would be better. I can tell you for us, we are most likely going to be uploading documents based on the year. So not just bank statements 2021, but physical presence 2021 with all the documentation showing physical presence for that year, kind of thing. Like, and that makes it easier for the officer. So if you can document your 10 years and have those files where it's like physical presence 2014, 2015, 2016, and just go through. I believe that's better for officers than just month-to-month bank statements, and it just gets tedious for them. And that way it's easier for them to kind of just go through and see, okay, is there enough here for this year? Is there enough here for that year? It just makes life easier. One rule that I have when dealing with USCIS is to make their lives easy. The easier we can make it for them, the better for us. So when we get to organize things for them that they don't have to think too much when it comes to, okay, where should I look for this thing? Oh, things are everywhere. How do I? Nope. Make it easy, and they're going to be able to get through the application faster than having to like open multiple files. I hope that was helpful. All right, so I do not see any other questions. Remember, this is not my normal live day, but I till Friday because I know some of you want this information today. And I want to get it out to you today as well. So I will be going live again on Friday. So feel free, join me, ask your follow-up question. This is a lot, over an hour of information. So just take it in, come back on Friday with your questions. If you have, if you have any additional questions, and we'll be, like I said, we'll be diving into the criminal history portions of this and the removal portions of this, the deportation portions of this as well on that live, just to get you more details. Okay. And like I said, the Federal Register will be officially published tomorrow on the 20th. So you can read that for yourself as well. If you have questions and you're watching this on a replay, put them in the comments. As always, if you want personalized legal representation, please feel free to reach out to me. Go to my website, lilylegal.com. Click on contact us, pick a time that works best for you. I do offer a free 15-minute consultation, so feel free to take advantage of that. Talk about your situation. Let's see if we can work together, what your situation needs, and get you closer to your immigration goals. All right. And once again, if I did not, I don't even think I introduced myself in this live, but thank you all for watching. I know if you're here, you probably know who I am, but if you don't, I am attorney Lillian Chukura, and I help my clients get green cards and citizenships for themselves and their families using the U.S. immigration law system. And that's kind of why this parole is such a big deal, and I will be talking about it for as long as I can. All right. Thank you all so much, and I will see you next time with more immigration news.